Welcome back, viewers and listeners. My name is Timothy Sweet. This is What Just Happened, Surviving the Family Court. We're now up to episode 11, the penultimate episode of this podcast. We're going to get into the heart of Pettinato v. Pettinato. Behind me on the camera, as always, is Guillermo Garcia, Pixels Digital. We have Tony Jones, Omni Media, as well as Patricia Raskin of Raskin Resources Productions, who's helped co-create and produce this podcast, and it's been long suffering for me and for this podcast, and we really appreciate all three of them very much. Last week we gave as brief as I was allowed to be on the primer on Pettinato v. Pettinato, the 1990 Rhode Island Supreme Court case, which is the bedrock for all decisions made on all child custody decisions anywhere in the Rhode Island Family Court. And we talked about why that's important for you and your attorney, and that an understanding, even a superficial understanding of this particular law, this case, how it was decided, and why it was decided, how it affects you, will bring you so far up to speed in understanding the subliminal language discussed between your attorney, the other party's attorney, and the judge. Because all three of them speak Pettinato, and hopefully, to some extent, you'll also understand Pettinato when you listen to this podcast. Pettinato was handed down in order to help Rhode Island Family Court judges determine which parent a child or children will live with and why. And in doing so, it set forth 8 specific factors. Your family court justice must consider these 8 factors, all 8 of them. Different ones will weigh different factors more importantly under the circumstances, but they're all bound to understand and apply these 8 factors. The very first Pettinato factor for determining whether a child will live with their mom or their dad is the wish of the child's parents regarding the child's custody, which makes sense, because the family court is not going to wade into those waters if the parents can agree. If 2 parents can agree as to where the child will live, whether it be with mom or with dad, whether it be in another state, the family court is not going to get involved unless under extraordinary circumstances. If you want to tell a judge that husband is going to move to Syria or some war-torn country and take the child, then obviously the family court is never going to allow that. But short an extraordinary disregard for the best interests of the child, then if the parents can agree and do agree on where the child or children should live, then the family court is going to stamp that. Number 2, the second factor, the reasonable preference of the child, if the court deems the child to be of sufficient intelligence, understanding, and experience to express a preference. It's another factor that sounds very simple and is not at all simple in application. So all this means is that if the child is of certain age and maturity, he or she should have a voice, not the voice, but their voice should be considered and should be persuasive upon the court as to which parent the child will live with. And that's always the easier question. I've always found it's easy for judges to ask 13, 14, 15-year-old children which parent they want to live with. And the much more interesting question, frankly, is why? Why did you choose that parent? You'll see a lot of parents will do well in having a child say that he or she wants to live with that parent because they're less strict. Is it because they have fewer rules? Is it because there are it's simply a nicer house, there are better gadgets and electronics? It's very difficult to tell why children make the decisions they do, especially when you put them under extraordinary stress of having them brought back to discuss which parent they would want to live with in chambers with the judge, given the emotional weight of that decision and the stress of having to choose one parent over the other. I'll tell you, I had a very interesting case come to an end 2.5 weeks ago, in which the father, now these 2 had been divorced some time ago, father had the children per the divorce, 2 boys, one a preteen and one a teen. They lived with father, and father had come into all kinds of issues as far as essentially drinking. and others. And so the boys went to live with mom temporarily while father could get his act together, frankly. And both of these boys were interviewed by the judge in chambers to be asked just this question: what is the reasonable preference of these children? And I'll tell you this, which is what I tell everybody who comes to my office to discuss the preference of a child, is that you don't always know. And what children say, again, under extraordinary stress to judges is never less than surprising. What these particular boys said was that they would prefer to live with their mother, but they were absolutely in love with the school district where father lived. They did not want to leave their friends behind, their sports, their activities, their teachers. And so that became an area of concern for the judge and for both counsel as to how to get these two children to live with mom when their reasonable preference is to stay in the public school district where father lives. So that's the first two. The first two factors focus on the preference of everybody involved, meaning both parents and the child or children. Factor number 3 in Pettinato: the interaction and interrelationship of the child with the child's parents, the child's siblings, and any other person who may significantly affect the child's best interests. Again, factor 3, the interaction and interrelationship of the child with the child's parents, the child's siblings, and any other person who may significantly affect the child's best interests. And I consider this the grandparent rule. If mom and dad are fighting over who should live with the child, and say, for example, mom lives with her mother, the child's grandmother, and those children are very closely bonded to the grandmother, then good luck tearing the children away from mom and grandmother and putting them with father, or vice versa. What happens more and more nowadays is if the children live with father, father has other children of his own, which are half-siblings to the kids in question, and those children are bonded. Again, if children are very closely bonded to half-siblings with whom they live with either parent, you can bet that the family court is going to try everything it can to keep those children with grandma, with half-siblings, what have you, with whom they're bonded. Because again, the court is only there to determine what's in the child's best interest. The court is not there to consider or kowtow to the preferences or conveniences of the parents. Factor number 4, the child's adjustment to the child's home, school, and community. The child's adjustment to the child's school, home, or community, or the harmony rule. The idea that the family court is at all times going to make Herculean efforts to ensure that if the child has, on the date of the court date, held certain life experiences, gone to the same school, been with the same babysitter, has a teacher he or she really enjoys, has pets at home, which he or she loves, is in a good neighborhood, is very intricately plugged into the activities of the community, be it soccer or football or choir, then the court is going to be loath to permanently change that child's community, school, neighborhood, and home unless absolutely necessary. For that kind of change to happen, the parent whose home is the basis of that community would have to find themselves unfit. Which brings us to factor 5. Number 5, the mental and physical health of all individuals involved. Notice it doesn't say the parents. It says the mental and physical health of all individuals involved, which of course means the health of the children, if that's an issue, the help of the support system for the children, whether it's neighbors, grandparents, the half-siblings we had mentioned, teachers, and of course the mental and physical health of the parents. If you think that, and this has come up quite often in 2017, and more often than it had previously in my office, if you think that one parent's trip to a mental health facility for any reason is somehow off record or strictly privileged or confidential, which of course it is in the real world, it is not in the family court. That is accessible that is relevant, it's probative. Your mental health history as a parent can and will be subject to scrutiny. It is one of the Pettinato factors. It's not one of my favorites, but it is weighed, it must be weighed by the judges. Do not think that your past is yours and yours alone and your secret, and that it's no one else's business, because the Rhode Island Supreme Court has said otherwise. Number 5, the mental and physical health of all individuals involved. Number 6, a bit redundant, the stability of the child's home environment. The stability of the child's home environment. I think a bit redundant over the harmony rule of the child's adjustment to his or her home, school, and community. But this is to say that if someone comes before the family court in a custody disagreement, then they should consider the status quo to be sacrosanct. Hopefully no one will move out. Heaven forbid no one will get sick. Hopefully no one will get evicted. The stability of the child's home environment is paramount in these Pettinato child custody decisions. Factor 7, which keeps the lawyers up at night, and which the judges frankly have the most fun with. The second to last Pettinato factor, Factor 7, the moral fitness of the child's parents. The moral fitness of the child's parents. The term moral being problematic in that this makes relevant so much information which otherwise would never weasel its way into a child custody proceeding. Anything that you can couch to be in terms of being probative of the other party's moral fitness can and will come in. The judge has to consider it. Now again, it's obviously up to the judge's discretion what weight to give it or to not give it. But anything having to do with the moral fitness of either parent is certainly game, if properly brought in per the rule of evidence, to determine which parent a child will live with. And before going on to 8, which is frankly the most important, a very brief recap of the factors. Number 1, the wishes of the children, its parents. The wishes of the children's parents. Number 2, the wishes of the child, if he or she is of a certain age and maturity. 3, the interaction of the children with the parents, grandparents, siblings, half-siblings, anyone that the children have lived with. Number 4, the harmony rule, the child's adjustment to home, school, and community, which will not be disrupted if there's any other way. Number 5, the mental and physical health, not just of the parents, but of all individuals involved. Number 6, the stability of the child's home environment. Number 7, the moral fitness of the child's parents. And number 8, the final and penultimate factor in Pettinato, the willingness and ability of each parent to facilitate a relationship between the child and the other parent. And this is the one that if you've been to family court with an attorney, your attorney probably hasn't shut up about it from the beginning. The willingness of a parent to facilitate a relationship between the other parent and the child once a decision is made. It's easier said than done, but given the hostility that is at the heart of all of these family court issues, once a decision is made which parent a child or children will live with, those hostilities are not easily forgotten. And usually the parent who, for lack of a better word, wins custody of the child can and will use that against the non-custodial parent in every and any way possible. And if the judge thinks for a second that if she places the child with mom, and the mom has shown extensive history of obstructing the relationship between the child and the father, then regardless of the other facts or the other factors in Pettinato, that judge will have, first of all, every good reason, and also every inclination to place that child with the father. The family court is such that at heart, if a child comes in with two parents, then that child is leaving with two parents. And even if, say, mom lives in a better community, has a better school district, maybe makes a little more money, maybe even has another child who's half-sibling to the child in question, if mom has shown through her own gratuitous efforts that she will not foster a relationship between father and child, then the judge is going to look long and hard at mom, despite having all the other factors weighed in her favor as to whether this child should live with her, because she is not going to foster a relationship with that father. And that child is going to have two parents when he or she leaves the court, no matter what the decision. So again, the eighth factor, the willingness and ability of each parent to facilitate a close and continuous parent-child relationship between the child and the other parent. That is the critical factor and the critical case law. And there is no other single sentence more important to your child custody matter than that. Plenty discussed there. More time than I have in studio. I would always welcome your feedback. TimothyMSweet@gmail.com. You can find me on just about any social media platform. You can find this video on YouTube if you are listening, and if you are watching, you can also find this audio on Spreaker, Stitcher, iTunes. I think we might be on iHeartRadio now. If we're not, hopefully by the time you listen to this, then perhaps we will be. Always welcome for feedback, especially on this topic. There is nothing I'm doing in my personal or professional life that I would not drop immediately to discuss Pettinato, your children, in your child custody case, how this affects you, and how you can use it to your advantage instead of just having to worry about it. My phone number, 401-595-1665, and we look forward to the next set of episodes with you. And we, more than anything, would love your feedback. A very special thank you again to everyone who helped me put this together. This is Timothy Sweet of What Just Happened, Surviving the Family Court. Thank you very much.